Hi again, this is attorney Robert Slim from Dallas, Texas, and today I'd like to talk about premises liability cases. These can include slip and falls, trip and falls, falling objects, or anything that has to do with some dangerous condition on someone's property. Premises liability cases are actually broken down into three categories, and each of those categories has a different standard of proof in order to prove a premises liability case. The first category is a business invitee or a business guest, and this is most commonly seen in situations where you're a customer in a store or you're eating at a restaurant. It also applies in landlord-tenant relationships. The main factor in a business invitee and a business guest is that you are present on the property for the mutual economic benefit of the parties. That means you're there to purchase something and the business is there to make money. And that's how a business invitee is normally defined in a premises liability case. Now, in order to be successful in a premises liability case as a business guest or a business invitee, you have to prove three basic elements of your case. The first element is that the condition must be unreasonably dangerous. So if you have a 6 or 8 inch puddle of water in a parking lot or on the sidewalk of a supermarket, that might not be considered an unreasonably dangerous condition. But if you take that same puddle of water and you put it in a shopping aisle or in the checkout line of that same supermarket, that probably would be considered an unreasonably dangerous condition. So as you can see, that element really depends on the specific facts and circumstances of your case. The second thing you have to prove is that the property owner either had actual knowledge of the condition or that the property owner had constructive knowledge of the condition. And constructive knowledge means that even though the property owner does not have actual knowledge of the condition, they knew or should have known of the condition if they had taken reasonable steps to inspect their property. So had they inspected their property frequently or frequently enough, then they would have discovered the condition. And if that is the case, then you have satisfied this second element. The third element is that once you have an unreasonably dangerous condition that the property owner either knew or should have known about, then the property owner has to take reasonable steps to either warn of the condition or remedy or fix the condition. So if you have a spill in a shopping aisle, then the property owner has a duty to get it cleaned up or get a wet floor sign out there until you can go out there and get it cleaned up. So you can see that in these situations, a property owner does have a responsibility to make sure that their property is reasonably safe. However, they are not an insurer of your safety. In other words, they are not automatically liable just because you fall or get injured on their premises. You have to actually demonstrate those three elements of your case in order to win. The second category of premises liability cases are those cases that involve social invitees or social guests. And these are situations where you're not there for the mutual business benefit of the parties. It's simply you're at a friend's house for a party or a cookout or some sort of social gathering. These are very touchy situations because now you are going after a homeowner. And homeowner cases are very hard to win, and the standard of proof is higher with regard to the level of knowledge that the homeowner has to have. In those cases, you still have to prove that there's an unreasonably dangerous condition, and you still have to prove that the homeowner failed to either remedy or warn of the condition. But their level of knowledge has to be that they actually knew about the condition. You cannot get a homeowner liable unless you can prove that they had actual knowledge of the unreasonably dangerous condition. So if you think that the homeowner should be liable because they should have inspected the premises and they would have found out or had constructive knowledge of the condition, that's not going to fly in a social invitee situation. You have to prove actual knowledge on behalf of the property owner. Now, the third and final category of a premises liability case involves trespassers. And these cases are very hard to win because a trespasser on property is going to have to prove that the property owner intentionally and without any justification caused the injury to the trespasser. And unless you got a property owner out there, burying mines underground, then you're just not going to win those types of cases. Now, there is one last thing I wanted to talk to you about with regard to these premises liability cases. They are very hard to win. The Texas Supreme Court has gone to great lengths over the last 15 or 20 years to stringently define the elements for being successful in a premises liability case. And the most difficult element is the knowledge element, the second element, proving that the property owner either knew or should have known of the unreasonably dangerous condition. If you slipped in a puddle of water in a shopping aisle, you don't know if that puddle of water had been there for 5 minutes, 10 minutes, 2 minutes, 30 minutes. And it is your burden as the injured plaintiff to bring forth evidence that that puddle of water was there for a sufficient length of time or was there under certain circumstances that the property owner should have known about it and corrected it. So if you just have a casual spill, it's very difficult to win those cases. But if you have, say, a puddle of water that is caused by a leaky AC unit or a leaking refrigeration unit, you may have a better chance of winning because now you might be able to bring forth evidence that the property owner knew about the malfunctioning equipment and should have either inspected the property more often and cleaned it up or fixed the malfunctioning unit at a sooner time. So as you can see, these cases are very fact specific and they are very hard to win. That is why I emphasize to everybody, if you're injured on somebody's property and you think you might have a claim, don't talk to the insurance company, don't talk to the store manager, call an attorney right away. I cannot stress that enough, because what you say in these premises liability cases can go a long way to hurting your case. So I would say call an attorney right away and get them on it. Well, I hope this video helped you, and of course, if you have any questions about any personal injury matters in the Dallas-Fort Worth or North Texas area, feel free to call me, 214-321-8225. Thank you.